The Kenco Electric, Inc. et al.
You ready to proceed, sir?
Yes.
I'm Barry Kiefitz, representing the appellant Frederick Williams. Sitting at council table with me is my co-counsel, Michael Srebnick. I'd like to reserve 5 minutes for rebuttal, if I may. Now, this is an appeal from a final workers' compensation order. The judge made very detailed findings of fact, and the underlying findings of fact are not an issue. The claimant fell 6 to 7 feet when a scaffolding gave way, landed on his back, smashed his head against the concrete floor. The judge accepted the testimony of claimant's treating physician. His primary treating physician was Dr. Steinberg, and the claimant suffered herniated intervertebral disc in the neck that both the doctor and the claimant indicated was very painful, cervical radiculopathy, carpal tunnel syndrome, and there was traumatic migraines. The judge went through the 5-step Social Security sequential process in great detail, found the claimant had not engaged in substantial employment. There was a severe impairment. Found there was no listing, but determined claimant cannot perform his past relevant work, and that there was no showing of alternative work in the community in sufficient quantities, and that the claimant had a catastrophic injury and was permanently and totally disabled. The judge then addressed the fraud defenses, 44105 defenses of the appellees that they had raised before the hearing. The judge rejected every one of them. But then you'll see on the record, page 83, there's a new underlying basis they raise at the time of the final hearing. They say, if I can prove he did engage in sex when he said he couldn't, and did so knowingly, that constitutes fraud, and we can cut off all his benefits. That's the end. No more, no permanent total, nothing. Now, the underlying facts for that defense are there was surveillance in August of 2004. His deposition was taken in September of 2005. And during the course of the deposition, he was asked, what other things can't you do? And, well, I can't have sex. And if you go on with the whole colloquy, not where the judge cut it off, but a couple lines after, clearly, he's saying I can't have sex with my wife, which he meant was intercourse. Following the deposition of the claimant.
Now, the fact that he was referring to sexual intercourse was not really made clear until the final hearing, was it?
That's correct, Judge.
So at the deposition, it was sort of left unclear.
Yes, but
depending on your dictionary definition of sex.
Yes, and that's another thing that we covered in the brief, that it's ambiguous. And
the man said he couldn't have sex.
Yes. I'm sorry?
He said he couldn't have sex. I mean, he didn't qualify it when he was in there.
Well, if you look beyond what the judge, where the judge cut it off, and the defense counsel, it wasn't ambiguous to her. The defense counsel says, "Oh, you mean you can't have sex with your wife?" And he says, "Yes." So it wasn't unclear to her that that he was talking about I can't have sex with my wife. Now, the point, though, following the next thing is the pretrial that was conducted in December of 2007. And at the pretrial, they mentioned nothing about this as an underlying basis. They mentioned several other bases that he denied at his deposition, talking about a neck injury he had before.
Well, didn't they raise that he had misrepresented what his physical abilities were?
Well, they generalized. There was a generalized defense that he misrepresented his ability to perform daily activities and the extent of his injuries.
But by his own testimony in the deposition, it appears, well, in the deposition when he was asked about things that he normally could do, he volunteered sex.
Yes.
And then volunteered, want to know how often I engage in it?
Yes.
And it was, 5 to 7 times a week? So
he made that
he made that as obviously a daily activity, did he not?
Well, he said before the accident, I used to engage in sex five times a week. But, the other point is, what does this activity of sex have to do with showing an intent to enhance and get benefits? There was no evidence in the record that he thought there was any loss of consortium claim. There was no evidence in the record that he was seeking any urological care.
But doesn't the McHale case say that the false statement does not have to be, or the misleading statement does not have to be material to the claim?
No, we know, yes, it doesn't actually have to be material, but there still has to be shown the intent of the claimant to try to misrepresent to get benefits.
Well, wasn't that the purpose of the deposition and the purpose of, the attorney asking, explain to me what activities you can't do, and then he volunteers that?
This is the guy who says, he can paint a house, that he put up storm shutters, and he says, I can't have sex. But there's no nexus showing any connection between I can't have sex and his intent to get any benefits.
But why would you say it except to get benefits?
Well, if you use...
Nobody was really curious about what he did in his personal time.
Right, but if you take that analysis, then there's never a boundary for determining intent. Then if the claimant says, I didn't have a bagel in the morning, and somebody shows he had a bagel, then the judge, well, you did that with the intent to
But he wasn't talking about a bagel. He was talking about his physical abilities.
Well, in terms of, I'm sorry, Judge, but may I just say, his physical abilities in terms of his ability to have sex.
And my question is, why would he even talk about that?
Well,
unless it was in order to obtain benefits.
Well, Judge,
it wasn't just a free will and discussion about what you do last week.
People every day of the week, they volunteer kinds of things and they talk about things but there has to be a showing someplace in the record for the judge to get to that conclusion that not just that he said it, but that the intent was to get benefits. So if they had asked him, do you know there's loss of consortium claim, even if we know there isn't, if he thought there was, or there's something in the record that he thought there was, that would be different. The McHale case, the claimant was seeking temporary benefits, and he said, I can't work, and they saw him at a strip club. So, you clearly have, that's a pretty easy case. And the Areola case is also, an easier case. It's a step away, but there the claimant misrepresented his Social Security number, and he had to give it in order to get employment. So you can get to the inference there that, well, in order to get these benefits, the pharmacy benefits, in order to get my comp benefits, the judge could infer that he gave a Social Security number with a view to getting benefits. But
counsel, it seems to me, as when I read his testimony and combined his testimony both in the deposition and at the hearing, it seems to me what he was saying is, I can't engage in sexual intercourse because I have an injured back and knee and I'm in pain when I do that. But I can have oral sex because it doesn't involve my back and knees. I think that's what he was saying.
Well,
and isn't that talking about his injury and how that limits his activity? And he's talking about sex, but I think that's why he brought it up. That's how I read it anyway.
Well, there is an element, maybe you can interpret it that way, that he did bring it out like that, but that brings out, when he says, I can't have sex, intercourse, because it's too painful, but then that raises the issue, as we just addressed in our brief, in terms of, well, does oral sex fall within, this category to the extent, and under this statute, to the extent that this man is just automatically barred from benefits.
But it's his self-report that all he engaged in when he was during the videotape, which I believe was almost 2 hours, was that he only engaged in oral sex, and that the judge though was having to determine credibility of the witness. And the judge could have just thought, I don't find that credible. I find that he's not being truthful, and therefore I find that this was misleading and it was fraud, and then we are.
Well, Judge, let me say this. They could have brought maybe they could have found the witness if they wanted to, and brought the witness to refute what he said, that that's all it was. But all we have in the record, yes, I mean, that's what the claimant said, but that's all there is in the record. So can the judge infer anything he wants when that's all there is in the record?
Sure.
He's a fact finder,
And
sure.
he's a fact finder.
I'm sorry?
And he's a fact finder.
But
no, let me finish. He's a fact finder, and it seems to me that what he found, and this is, McHale talks about when there's a contradiction in testimony, then that really is considered either incomplete or misleading testimony.
Well, I understand the judge is the fact finder, but I think there has to be a basis for his finding, as I'd indicated. May I go on with the argument in terms of the procedural argument? Because
You're
I think
into your rebuttal time.
Okay, let me just spend a minute on the procedural argument, because I think that's a very significant aspect. This matter, this underlying basis, was not raised until the time of the final hearing. Now, the scenario for this is, following the pretrial where it wasn't raised, there was a trial summary submitted that does talk about what activities they are talking about. And the activities they were talking about was he denied owning a boat, denied working on a boat. That's all the activities. There's nothing about this underlying sex aspect being raised as a basis for the 440-105 fraud. There was then an amended trial summary 2 days before the final hearing. And again, they reiterated the other defenses they had in the pretrial, and they raised a new one, that he didn't tell his vocational counselor he's the director of vocational, he was the director of operations, etc. The judge, all of those were rejected. Again, this sex aspect was not raised. Now, opposing counsel tells us that, well, we signaled it on the pretrial, and that, of course, goes to your question, Judge. I don't think, first of all, I dispute that, and I don't think that signaling is an acceptable due process standard. This court in Vargas said parties are entitled to notice of what's being litigated. And we quoted from a trial decision in Cambrone, because of the reasoning of the court, due process requires sufficient information to defend.
And wasn't the extent of his physical abilities
I'm sorry?
And wasn't the extent of his physical abilities being litigated?
Well, the generalities of it were not, at least from the trial summaries they submitted. Then if we would have been better off with just the generalities without them submitting the trial summaries, because if we're talking about signaling is enough, then the trial summaries certainly signal that they're somewhat deceptive.
But better off and due process are different things.
I'm sorry?
Better off and due process are different things. I mean, if you were on notice that the extent of his physical abilities was going to be litigated.
Well, Judge, when you talk about physical abilities doing anything, I mean, that's an awfully broad kind of thing. And yes, I don't think that's a satisfactory due process standard. And the judge in Cambrone didn't. I don't think this court in Vargas would have approved of this general kind, well, his abilities. I mean, I don't think, we can properly defend, but we were misled then when they list everything else out in the trial summaries, and they leave this out to be raised at the last minute a couple days later.
But aren't you signaled when they mention that they have videotape evidence to corroborate this, that this was one of the videotapes that they had? So this might be something we need to consider?
The judge looked at the videotape, and the judge said in paragraph 60 of his order, the judge says, hey, there's nothing in this videotape that contraindicates anything the claimant said. So if we looked at the videotape, there's nothing in it that would...
What I'm saying is, though, the fact that they're saying that there's videotapes that are going to corroborate their side, the fact that you have videotapes of, I guess, him with this other person, that you'd be on notice that this is something that there's going to come up.
Listen, I think this is too important. And I know when we make a claim, we got to make a very specific claim, not expect the other guy to sort of try to figure out what we're claiming. And this is a nuclear defense that we're talking about. And I think that I think you have to have a little more knowledge on the underlying defenses, underlying basis, so that you can defend. And that's what the judge in Cambrone thought, and struck the defense because they didn't give the underlying basis until 2 days before the hearing. And here we have the additional element of seeming deception. I think, this case, I think, falls within the Isaac versus Green Iguana, which Judge Van Noordwijk authored, and the Vargas decision. I'll save whatever time there is for rebuttal if there is any.
May it please the Court, I'm George Kagan speaking on behalf of the appellee Kenco Electric and PBOA. The argument is very much along the lines of Humpty Dumpty's words mean exactly what I want them to mean. He uses words like nuclear and signal, but he is very casual with the words that he has rephrased his point on appeal with. The point on appeal, number one, is referencing oral sex as though the judge found there was oral sex. The judge made no such finding. The question is, as we rephrase the point, did the JCC, was he substantiating a finding that the claimant had knowingly, intentionally misrepresented the extent of his physical abilities and limitations in an effort to obtain workers' comp benefits? Let's talk about the word nuclear, which goes to the core. Let us go to the actual question and answer for just a moment. What can you do that you no longer what can you no longer do that you used to do before? The first answer is very interesting, especially when we talk about painting with tarps and boat repair. I can't do anything that I used to do. Well, for present purposes, we're going to skip the tipsy coachman argument. Here's the next question. Can you give me specific examples? Now, claimant's talking about bagels. This is no casual aside. This is not, who do you root for, the Yankees or the Braves, and then you find them with a Brave costume on. No. This is the nuclear question of the workers' compensation case. Give me specific examples of what you can't do now that you used to do before. I can't have sex. And as Your Honor noted, he jumps into this, both feet on the ground. When was the last time you had sex? A couple of years ago. You want to know the average my sex was before that? And then I think the answer is very interesting. Counsel Bites says sure, and the answer is 5 to 7 times a week. 7 times a week happens to be daily activity. Now let's look at the pretrial, and the pretrial stiff, which claimant, again, with their word semantics, the rhetoric is very interesting considering how they've trimmed our pretrial statement in his brief at page 2, which we explain at page 4 by restoring the full context. And our pretrial statement is, and the reason I want to emphasize this is because the questions that came up in oral argument. Yes, there was a brief discussion on the record about what's this all about here with the prostitute. And it was explicating what's in the pretrial, which frames the issues, and I'll get to the word signal in a minute, and that is that claimant misrepresented his ability to perform daily activities and the extent of his injuries. However, surveillance taken demonstrates that the claimant has none of the physical limitations he alleged. Now, the claimant doesn't like the word signal that we used. Well, a traffic signal is pretty clear. An officer signaling to you to pull over is pretty clear. And this was a perfectly solid emblem in the context of the workers' compensation case of what we were relying on and how, almost paradoxically, it dovetails precisely with his 7-day-a-week estimate. We said daily activities. He made this a daily activity in the sine qua non.
In terms of his workers' comp claim, what's it matter if he can or cannot have sex?
Well, in a nutshell, in the vacuum of your Honor's question, it doesn't matter. But when a claimant in our discovery deposition, all right, how are you impacted by this? Now here, we go into the tipsy coachman about remember the judge found nothing that he had to say except the description of the accident was credible. We highlighted that finding, Your Honor, and we cited in our tipsy coachman. The judge made specific findings of fact that everything this man says is troublingly, disturbingly misleading. His attempt to portray his illiteracy as a chief of operations of a pari-mutuel betting facility and a business owner who's still running businesses, and he tells in deposition he can hardly read. Words to him are just like firewood. the judge specifically found, and I'll get to that in a moment, that he doesn't believe anything the claimant says except the description of accident. This is why we go to tipsy coachman. So when you say, what can you no longer do? In our discovery deposition, look at the statutes that we're talking about here. Claimant likes to pound the table on the word fraud and use civil cases. He retreated a little bit in his reply brief. But the statute says it doesn't have to be fraud. It can be misleading or incomplete. And that's why we go to tipsy coachman. In other words, we're not asking, as the claimant says in the reply brief, for the court to make findings that the judge did not make. We're asking the court to give efficacy to the findings the judge did make. We didn't have to cross appeal having won the case in toto, but we should not forfeit the right to argue things we could have said in an appeal had we not prevailed. And one of the things we say is the judge has made numerous findings here that preclude an award of compensation benefits. Finding number 49, for instance. Here's what the judge says. Mr. Williams' testimony with regard to how his compensable accident occurred was credible and trustworthy. In other respects, however, his testimony was less than entirely accurate and raised serious concerns. He specifically finds, in paragraph 37, claimant's explanation of his ineptitude and illiteracy regarding the chief of operations of a parimutuel betting facility was not credible. That's a misleading, misrepresentative statement. The judge found it. So in our tipsy coachman argument, we're kind of nonplussed as we read the order. A layman reading the order might say, why is painting a house on consecutive days with a tarp over your shoulder, washing boats for hours at a time, how is this consistent with the doctor's testimony? The doctor, incidentally, was misled about a prior cervical injury. And the judge said he mentioned some things about the accident, so he probably intended to not misrepresent, which does not fit in perimetry with his overall finding that everything the claimant said was not trustworthy. But the doctors accommodated the misrepresentation, even though they said they didn't, by altering the rating and saying, in terms of major contributing cause, most of this probably is from your accident. This was accommodating the fact that they had uncovered his concealed cervical injury 2 years before our cervical injury. A reasonable person would read this order and get to the final paragraphs and say, what took the judge so long to get to that? That's the heart of our tipsy coachman argument.
But the trial judge actually rejected the employer carrier's position with respect to some of the alleged misrepresentations, did they not?
Yes, they did, Your Honor, and that's why we go to the heart of our tipsy coachman argument. Some facts derive no added gloss from the trier of fact superior vantage point. For that case, we cite Maller versus Lauderdale Lakes. The court sits in a superior position to see what conclusions should have been drawn from the fact the judge made so many findings that the claimant was not credible. It's not credible about bagels or sports teams. It's not credible in his answers in discovery in a trial about the nuclear benefits of this case.
But the only thing the trial court addressed in terms of that issue had to do with his testimony concerning his sexual activities, was it not?
Exactly so.
I am a little troubled. It seems to me, as the JCC pointed out, not every testimony that is incorrect or a bad memory constitutes a basis for denying benefits.
Absolutely correct.
And I think that's what concerns me.
That's why I started, Your Honor, with the quote and the question and the significance of the question and where the prominence of it in this deposition. What can you do that you no longer do? I can no longer do anything. Let's see that that's hyperbole, Alka-Seltzer commercial, the best product on the market. But what specifically? Well, I can't have sex, and I had it every day. And here's the finding, Judge 57. The clear implication of Mr. Williams' testimony was that physical limitations resulted from his compensable accident prevented him from engaging in sex at all. His attempt to downplay his physical abilities was not accurate. This is the explanation of oral sex. The judge did not buy that explanation, and yet, like a child who says, I should be excused from my homework because aliens abducted me, and the judge doesn't, and the teacher doesn't accept that as an excuse, the child doesn't get to run around and say, can you believe even though I was abducted, the teacher didn't accept my homework? Well, the fact is the teacher didn't accept that explanation. Here is the explicit finding, Your Honor. That was not accepted. What he did accept was, out of respect for his privacy, we're not going to discuss it explicitly, but suffice it to say that his testimony at the final hearing wherein he attempted to explain away the apparent inconsistency was not convincing. Here is the trial level advantage. Here is the deference that must be due. Here is the inference which judges draw every day, which they are compelled to draw from ambiguous circumstances, and to put the cap on it. Counsel said in response to one of your questions, you could interpret it that way. Well, the judge did interpret it that way. And that deference is pretty clear in this case, must be given the judge to draw the reasonable inferences, and especially this isn't some ambiguous act and an ambiguous finding. Look at the trouble the judge went to explain exactly his thinking. This was not convincing. The undersigned does believe that Mr. Williams has limitations, and by spending the first 2 minutes on the benefits that would otherwise be awarded, it's beside the point, which are the direct result of his injuries. However, they are not as limiting as he attempted to portray them. This is a misleading and incomplete statement the judge is plugging right into the statute. In the quoted exchange, the undersigned concludes these were knowing and intentional misrepresentations made in an effort to obtain workers' compensation benefits. And one of your questions hit the nail on the head. We weren't talking about bagels. We're talking about what you can't do now that you used to do for the intercession of this accident. It's the nuclear question that was asked and misrepresented in explicit terms. And if the conduct that the judge looked at in the surveillance films is capable of disparate interpretations, the judge cannot be faulted or second-guessed on the inference that he drew that became the final binding finding of this case. And for that, Your Honor, we think that there is no merit to either the point one on appeal, where it harps on the oral sex, which never was a finding in the first place, and the pretrial statement claimant misrepresented his ability to perform daily activities to the extent of his injuries. Surveillance films demonstrated he had none of the physical limitations. Now, of course, that can excuse the tarp and the painting in the boat and the scuba diving, but it didn't excuse the one I just articulated in great detail. And that is the hat that must be hung on this case and this appeal. The constitutional arguments, I'm not sure that you're interested in. We're prepared to discuss them, but I don't think there's anything to see here, folks, in terms of a constitutional jeopardy. The McHale case, with which I am somewhat familiar, addresses the materiality issue, and Your Honor hit the nail on the head in terms of it is not so much that he misrepresented the degrees to which he's capable of bending or not bending, but rather that when he formulated the answer, it was in part to secure the benefits of workers' compensation. And that's, like, I go back to the nuclear question, what can't you do now? Answer. Okay? And the Areola case with the Social Security, in our opinion, the attempt to reconcile that case with the point on appeal is illusory. What benefit do you get from a Social Security number? We are more close to the core question in this case than the Areola case. And we are exactly in line with the McHale case, where the judge made the explicit finding, based on the inference drawn from the film, that this was a deliberate and knowing attempt to mislead and misrepresent his activities, and that's all that the statute requires, Your Honor. It's not a fraud case. And even if we go to the fraud cases in civil, you notice I filed a notice of supplemental authority a few days ago, the Hutchinson versus Plantation Bay Apartments, even the civil dismissal that claimant referred to in the initial brief, which he retracted in the reply brief, shows that even in the plain common law dismissal cases, false misleading answers meant to stymie discovery on issues central to the case supported the dismissal, and the judge in that case did not buy the memory problems, which are cited as the reason for the misleading testimony. So even with the higher standard there, we have a good authority for the kind of conduct that the judge looked at and judged. And there is no grounds urged that I have heard that is cognizable at law to alter the outcome at this tribunal. We respectfully request that the court affirm the order of the judge of compensation claims, or in the alternative, look at the Tipsy Coachman argument and realize there were numerous other grounds upon which to deny this claim, who the judge found was gaming our system. Thank you, Your Honor.
I'll give you a total of a minute to wrap up.
Why wasn't this underlying ground at least mentioned in the amended trial summary 2 days before the final hearing? Brought for the first time at the final hearing. Opposing counsel says that the judge didn't believe anything that the claimant said other than regarding the accident. In fact, we're satisfied with all the findings of the judge up until this one finding, and opposing counsel was very quiet. I have to bring out to the court However, they are not as limiting as he attempted to portray them in the quoted exchange. So all we are talking about, as far as the judge is concerned, is that little quoted exchange about sex, nothing else. I suggest that the judge's order needs to be reversed. Thank you.
Thank you, counsel. Thank you both. That completes our docket for today.